think both the Polly Strong case and the Mary Clark case are remarkable because of when they happened. They both happen almost at the very beginning of statehood. And they are resolved with writings that I think are in many ways elegant, that speak both to legal principles and to sort of the way that human beings deal with one another.
Polly's story is somewhat different than Mary's. Polly was a 24-year-old slave of a man named Hyacinth LaSalle, a prominent local citizen and owner of the area's largest hotel and tavern. Polly and her brother James were slaves because their mother Jenny was a slave. She had been purchased from Indians around 1795 by Antoine LaSalle, who then gave Polly and her brother to Hyacinth, his nephew. So in 1818 Vincennes, Polly Strong was bound as a slave, and Mary Clark was bound in involuntary servitude. And there are numerous others in the same situation. Many had petitioned the Knox County Court to gain their freedom. None succeeded.
We know that there were people holding slaves in Indiana, and people in pretty high positions in our state government were holding slaves. So I would definitely say there was at least a portion of the population that was not happy with that provision.
It was around this time that 25-year-old Amory Kinney migrated to Indiana from upstate New York.
Kinney comes to town and sets up as an attorney, and he apparently is shocked to discover that contrary to the state constitution, slavery and indentured servitude are being practiced here in Indiana. And he introduces a number of habeas corpus proceedings in the Knox County Court. Habeas corpus means you have to produce the body. It was a method for obtaining freedom for slaves. You must show why, contrary to the law of the state or the law of the government, this person is being unjustly held.
In January of 1820, Kinney filed a writ of habeas corpus in the Knox County Circuit Court in Polly Strong's case. He argued that because Polly was born after the Northwest Ordinance, she could not be considered a slave even if her mother was. Her master, Hyacinth LaSalle, strongly disagreed. Finally, on May 1st, a decision was reached by the judges.
The Knox County Court, following the way the law had been interpreted, says Polly Strong is a French slave, her mother had been a slave, and Polly is the child of a slave, and therefore is a slave herself, and therefore she is a slave. In fact, the judge makes a comment that, as far as you're concerned, this is a slave state.
The traditional argument about slavery in the United States follows the legal status of the mother, and her mother was clearly a slave. No one had argued that position, but the court and the local court bought LaSalle's argument, favored him.
Amory Kinney and his associates lost no time filing an appeal to the Indiana Supreme Court. On May 12th, only 11 days after the Knox County verdict was handed down. In July, the Supreme Court met at the state capitol in Corydon. On their docket was Polly's appeal. The chamber was on the second floor, just across the hall from the Senate chamber.
It is hard to imagine that this room is where the long story of Indiana law starts. It's such a modest and simple place. This is where the three judges, they were called judges then, not justices, the three judges of this brand new Supreme Court would come periodically. They would have come by horse, obviously, not by carriage, no roads to run a carriage on. They've had just a very few law books to carry from one place to the next. Books weren't very common at all. Law books were even less common. So you'd have put those in your saddlebags, and the judges and the lawyers actually would travel around together. On the days when there would have been decisions to be made about the central political question in American life, which was slavery, there'd have been enormous interest and enormous pressure, because although Indiana was a free state, it also had plenty of roots and plenty of friends in the South. When judges were called upon to decide matters that really cut at the heart of the issue, they'd have known that there were a lot of their fellow citizens who felt very deeply about the value of slavery.
So the three Supreme Court judges, Isaac Blackford, Jesse Holman, and James Scott, heard the arguments from the attorney for Hyson LaSalle and from Amory Kinney. And on July 22, 1820, Judge Scott read the court's decision.
The framers of our Constitution intended a total and entire prohibition of slavery in this state, and we can conceive of no form of words in which that intention could have been more clearly expressed. Slavery can have no existence in the state of Indiana, and of course the claim of the said LaSalle cannot be supported.
So the first Indiana Supreme Court reversed the decision of the Knox County Court. Polly was set free from LaSalle, and he was ordered to pay her court expenses.
We have no idea what happened to Polly. Polly just disappears from the historical record after the case is heard. We don't know anything else that happened to her.
The case of Polly versus Hyson LaSalle certainly was a landmark case in Indiana, and it helped set the precedent by which other similar cases would be decided. But it did not end the reality of slavery and involuntary servitude in the state.
Was there a difference between Polly Strong being a slave and Mary Clark being an indentured servant? In actual practice, not. In fact, you'll find in Vincennes people carelessly, usually the term was you would talk about servants. We have these servants. But occasionally they would slip up and refer to them as slaves, and I think mentally regarded them as slaves.
The issue of indentured servants raised more complicated legal questions. Masters continued to buy and sell indentured servants, arguing that the constitutional prohibition applied only to indentures made outside the state after its adoption.
So the Supreme Court decision in Polly Strong's case implied but did not explicitly state that involuntary servitude was unconstitutional. The court would soon have the opportunity to make it more explicit.